been a long day. So I get to do a rebuttal argument to essentially rebut what the defense states. So it might be a little disjointed, but I'm simply just responding to some of the defense's arguments. When you think about this case, there's a saying in law school that when the law is on your side, you argue the law. When the facts are on your side, you argue the facts. And when neither the law nor the facts are on your side, you distract from the truth. And ladies and gentlemen, that is what the defense has been doing for the last 3 weeks. Trying to distract you from the defendant's lies. Trying to distract you with Alex's journals. When you go back to the first week of testimony, witnesses are up in that witness stand testifying about what they saw, what they heard, and the defense cross-examines them by reading from these journals to distract you. Just like the Soren Kierkegaard book, to distract you from the cover. When the defense mentions these journals, it's important to note that the defendant admitted that these were metaphorical in nature. She knows they're metaphorical. And when you consider whether she had this belief that Alex was this type of person, you gotta use your common sense. If she was afraid of Alex, would she have drove out there that day to see him? Would she have walked into his house, gone up the stairs, shut the door, sat on his bed? Would she have said, let's go in my car, let's go for a drive? No. The defense is trying to use these journals to distract you from the defendant's statements and what happened that day on March 22nd. The defense had a number of experts. We spent a couple of days talking about psychiatrists and psychologists, talking about how brain circuitry works. But let's call a spade a spade. The defense hired professionals to try to explain away the defendant's repeated lies and try to make the facts in this case fit. So I'm going to go through some of the defense's closing arguments. And they talk to you about reasonable self-defense and what the self-defense standard is. But there's nothing about the defendant's statement that is reasonable. Her statement does not match the crime scene. It does not match the physical evidence. When you consider the reasonableness of her statements and of her actions, you need to ask yourself. So she testifies that there's this fight in the back seat of the car. Despite the fact there's hardly any evidence of blood in the back seat of that car. And then she wants you to believe that after this person, Alex, has attacked her, that she goes out there because she's a nice person to help him pee. That is not reasonable, ladies and gentlemen. If you are afraid of someone who just attacked you, such to the fact that you had to stab them 15 times, you get the heck out of there. You run and cry for help. You take that cell phone and you call 911. The defendant doesn't do that. And that makes this self-defense argument unreasonable. The defense brought up this mud on the mud on the car. I know it's a little bit hard to see. And this is the defendant's statement when she testified in court earlier this week. And she states, yes, one of my boot had come off. Do you know which one it was? No. And did you later take off another boot? Yes. Had you done this at this point yet? No. So in order for the defense's argument to make sense, she'd be wearing her boot. She's not wearing her boot, and that is not a boot mark. That is clearly not a boot mark. The defense states that there's no evidence of a struggle when you look at the mud of the crime scene. There's no evidence of a struggle here outside.
Can I see that? Sorry.
I'm sorry, it's the...
Judge, can you approach?
Okay, so the defense is talking about how there was not any evidence of a struggle in the mud outside the car. But then you need to remember that she told Detective Prock in her March 24th interview, the first place she thinks she stabbed him is in the head. And when you look at that stab wound, you've seen it enough, I'm not going to put it back up there, it's angled towards someone coming behind them. And then you think about the amount of force to go through the temporal bone, the amount of force. And so Alex is outside, and the defendant comes behind and whacks him right in the head, through the brain, through the temporal bone, completely disoriented him. And there's no evidence in the mud, according to the defendant's story, that Alex was laying on the ground. There's no handprints of Alex laying on the ground. There's no mud area showing that Alex was laying on his coat. The defense tells you that you heard the defendant in hystericals. She was hysterical in that squad video of Trooper Knutson when she went to Don Sippel's. But you need to remember the testimony of both Don Sippel and Emmer Shields. No tears. In fact, Deputy Shields testified that she was trying to be upset. Joe Wayne asked her about specifics, and she's able to say, Jason Mengel, a medic, M-E-N-G-E-L, Jason Mengel, she's able to remember. The defense tried to state in their closing that the state said that Alex opened the car door. The state has never said that. The state has never alleged that Alex opened the car door. In fact, so these little stickers are indicating the DNA results. Alex Woodworth's DNA is on the handle. He's getting in that car to get away from the woman who's stabbing him to death. He's trying to pull that door shut to get away from her. The state never alleged that Alex tried to open that door. The defense then argued about Alex's pants, but you need to remember the testimony of Dr. Mills. She testified that the blood on his pants was not consistent with someone standing up. Rather, it was consistent with someone sitting down when you looked at the rear.
Judge, objection, that's not what she said. That's the mistake.
Well, it's up to the jury to decide what she said.
The defense also stated in their closing argument that if the defendant was concerned about getting rid of Alex's body, getting rid of the crime scene, that after she was in the hospital, she just would have gotten up and walked out of the unit. But that is also a misstatement. There was testimony that she was in a locked unit. She was not able to go back and fix the crime scene, and that is why she had to resort to Plan B when Detective Prock confronted her. The state has never claimed that the defendant carried Alex. The defense argues that, so the defendant says that Alex is outside of the car when she leaves. That's what she testifies, or what she tells to Detective Prock on March 24th. She states he's laying on the ground, laying on his coat, and I think he's dead or something. When she testified here in court, this was a new story. A new story where she states that she stabbed him 15 times in the car, and then he goes over to walks away, and she goes over to help him pee. I mean, this is just ridiculous. It's not reasonable. This is when you use your common sense. The defense talked about, do you have a picture of the crime scene? Could I have this screen? So the defense talks about the footprints at items 4 and 5. And the state does not dispute that Alex went back in that car. That has been the state's theory. And that is what the evidence shows. That when you look at all the blood outside that vehicle, he was stabbed outside that vehicle. And as I said earlier, she came behind and absolutely disoriented him. And then stabbed him in the scrotal sac across the neck and took him by surprise. He goes in that vehicle. Of course his footprints are going to be there. His footprints are facing in that car so he can get away from the woman who is stabbing him to death. I'm done with this reading. The defendant's own expert, Dr. Tovar, testifies that Alex's wounds could have been post-mortem. Their own expert, Dr. Tovar. And then they talk about how if she had really committed this homicide, if she had killed Alex, why did she go to Don Sipple's? Because her car was stuck. She had no place to go. So she goes to Don Sipple's. The defense tried to infer that the state used this John Hansen information as an attempt to attack the defendant's sexuality. That is not the reason why the state used any of that evidence. The state did not call John Hansen because this case is not about John Hansen. This case is not about Jason Mingle. This case is about Alexander Woodworth. That is why he wasn't called. The only information that you got about John Hansen with respect to the text messages, which were sexually explicit, was in response to the defendant's statement that this was a BDSM case, which is, again, new when she testified, that this was some sort of BDSM. And if you remember that text message with John Hansen, it's about, wanting to get tied up. That is why the state used that evidence, in no way to judge the defendant. The defense in their closing statement talked about the knife and the DNA on the knife and how the defendant's blood, they don't know whose blood is on the handle. But we know that that there's blood on the blade and that it's Alex's blood. But you need to remember that the defendant she absolutely admits she carved Boy in her arm after she stabbed Alex. After she stabbed Alex, she uses that knife. So the defense is just trying to distract you. There's no question that she used that knife because she admits she used it after she killed Alex. So I don't have the timeline, but Mr. Dufour went through the timeline. And we heard the defense come up here and argue, this happened quickly, super fast. But what happened for 2 hours and 50 minutes down that mud road? What did the defendant do? She staged a crime scene. Can I have the screen again? Sorry, Anna. That green trailer has the defendant's blood on there in 2 different spots, about 6 feet apart. How does her blood get there? You saw her wounds and scratches. They didn't even need a Band-Aid. They didn't even need a Band-Aid. So how do you explain that blood there? And how do you explain her blood on that door? A long drip of blood. This is the defendant staging that crime scene for the 2 hours and 50 minutes that she had. This is the defendant tearing her clothes, creating injuries, trying to get Alex out of the car. The defendant, sorry, I'm done with that, thank you. The defendant told law enforcement, nurses, medical staff that she was attacked. I mean, that she's scared and that she's attacked. But what doesn't she say? Anything about Alex. Anything about the fact that Alex is dead down that road. The defendant said that, or testified here in court at the trial, that Alex said, "I deserve you one last time." And go back to her interview with Detective Brock, when she is asked specifically, "Do you think Alex was going to sexually assault you or something?" And she says, "I don't think so. I think he just wanted to look at me." She makes no mention of "I must have you one last time." This is the defendant who is continually changing her story to try and make it fit the facts of this case. The defense wants you to have a specific explanation for every piece of physical evidence. And that's just an unreasonable burden. I mean, the physical evidence is a huge part of this case, but what the state does is follows the physical evidence. And the physical evidence shows that this attack happened outside the car, because you use your common sense. The blood is outside the car. I have the screen again. The defense in their closing was talking about the abrasions to Alex's knees. And this picture illustrates Alex's knees stuck in between the two seats. And his sweater pulled up. This is the defendant trying to get Alex out of that car and not being able to in the 2 hours and 50 minutes she had to try to figure out what to do after she lost it and killed Alex by stabbing him 16 times. Let's talk about the defendant's injuries. The defense likes these photographs from the SAIN exam where they're distorted. I mean, it's bad lighting, they're not very accurate. But this is the next day. This is the defendant grabbing the blade of the knife. Defense stated that in her March 24th interview that she never pulled the knife. And she states, "How did you get the knife from him?" Respondent, "I grabbed it. I grabbed it from him and I pulled." Thank you. Can I go back to the screen? This is again a defendant who realized you can't have that type of wound from grabbing the blade of the knife. So now I'm going to switch my story around. And I'm going to say, I kneed him and then picked up the knife despite the fact that I can't see and I didn't have my glasses on. This is a defendant who is trying to distract you and trying to conform the evidence to the facts of her case. The defendant likes to talk about the mark to the defendant's neck. The next day, that mark is gone. This is from, March 24th. I apologize, it's 2 days later. March 24th, you do not see that mark. In fact, the defendant's own expert, Dr. Tovar, testified that that red mark under the defendant's jawline could have been a rash. And then their other expert, Dr. Thomas, testified that a mark, like that red mark from the SAIN exam, wouldn't likely be caused by skin-on-skin contact. The defense wants you to say, this mark is from her being pinned in the back of that car. But she was never pinned in the back of that car. She attacked Alex from the back, and those facts show that. These facts show that. Jennifer Morris testified there was no petechiae in her eyes. She said in her experience, if there's strangulation, she sees petechiae in her eyes, and she never saw that in the defendant's eyes. I think I'm good. Oh wait, one more on the screen. There's also this. The defense had the sane one, which makes it look a lot different than it does there. And you need to remember this is on the right thigh, right where your hand would fall. And you see those long parallel lines and those two that are off to the side, which are parallel to one another. Okay, thanks, Anna. And when you consider the testimony of the defendant's experts in this case, let's take you back to Dr. Tillotson. Dr. Tillotson, who was extremely clear, these are self-inflicted wounds. And his description made so much sense. It's so common sense. I mean, if she admits that the boy in her arm is self-inflicted, and if someone is holding you down, you're not going to get that same depth. And you compare the arm to the hand, to the thigh, to the groin, and they're all very similar depth. And then you go back into characteristics of self-inflicted wounds. Parallel lines within the non-dominant hand. She's right-handed in the left hand, left forearm, right where she would reach on her right outer thigh, and in the groin. And albeit the groin is even less deep than the other. And then you have to consider, so if Alex was cutting the defendant, as her story states, he's outside the car, he's cutting her in the groin through the clothes. He would have to, the marks go, I'm not going to show them to you given how late it is, but the marks go up towards the defendant's left side, up to the left. So in order for that to happen, Alex would need to be positioned over her using his right hand and curving it up. It just doesn't make sense, ladies and gentlemen. It doesn't make sense. And then you consider what Dr. Tillotson said about hesitation marks. How a person can get similar depth because, ouch, that hurts. Ouch, that hurts. But I need to put these wounds on me because I just killed Alex. And they're all of similar depth because as a hesitation mark, you know how to control. Dr. Tillotson, who has been a doctor for 30 years, said that he doesn't even know until he gets the scalpel in, and that's what anesthesia is for. Now the defendant's experts, Dr. Tovar, Dr. Thomas, want to say that these could be inflicted by someone else or they could be self-inflicted. But when you consider that Dr. Tillotson is not being paid, was actually trying to help his patient, and saw the depth of these wounds, and you use your common sense, it is clear that these are self-inflicted wounds. Very briefly, the defense talked about intent to kill, and that the state's motive makes no sense. The defendant's testimony is that she came over to Alex to try to be friends and try to get on, But I want to show you briefly the journal that she wrote. This is journal number 2 that she writes from the night before. And she states, I would consider suicide daily. My mind would tell me I'm a failure and a monster to become one of them. Told what to do and what to feel, using intellectual advantages against someone vulnerable and confused. I was so blind and followed the progression mindlessly. I was so close to ending my life. And this is how she describes Alex. I never gave their number or name in my contacts. I would look at them and not see beauty, but a big nose, a red nose too big for a face, where eyes looked dead, a brow jutting out of a large bulbous forehead, a smile that would make me cringe. Pores and veins stuck out on pasty, translucent skin, all felt like bugs under my skin. The scar on their wrist, red and deep, who was I kidding when I lied and told them otherwise? That was the defendant's feelings about Alex. the night before she killed him. Briefly want to go over the reasonable doubt instruction because the defense showed you part of it. I want to show you the rest of it because this part is important. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give the defendant the benefit of a reasonable doubt if it arises in your minds after you've carefully considered all the evidence in this case. Ladies and gentlemen, there is no reasonable doubt. There was no attack on the defendant. When you look at intent and you ask yourself, did she intend to kill Alexander Woodworth? Absolutely she did. You can look at not only the number of wounds, 16 times that she stabbed him, but you can consider the locations in that intent. The locations in the back of the head, slicing the neck, the scrotal sac, in both lungs. That shows intent to kill. And then you can think of her actions after. She takes his phone, destroys it and ditches it, doesn't call 911, doesn't get help for Alex. That shows that she intended to kill Alexander Woodworth. So when you go back in the deliberation room, you're gonna have to pick a 4-person, and then you're gonna have these 4 different crimes for you to consider. But you start at first-degree intentional homicide. If you don't believe the defendant's story, there's no question. You stay at first-degree intentional homicide. Then and only then, if you cannot all reach a consensus, then you can go to second-degree intentional homicide. But the facts of this case show that this was intentional. At the end of the day, this defense relies on an admitted liar with everything to gain and defense experts that have no firsthand information of what happened in this case. Regardless of any motive, there is no doubt that she intended to kill Alexander Woodworth. The defendant viciously stabbed him 16 times and left him there to die. And instead of getting help, she distracted law enforcement. Go to Owen Park. Forget about the man that I just stabbed and left there to die. When you look at these wounds, this was not anger. This was rage, and this was personal. The defendant needs to be held accountable for her actions. The state has shown beyond a reasonable doubt that the defendant, the self-described tricky fox, has committed the crime of first-degree intentional homicide, and I ask that you find her guilty. Thank you.